In 1976, the District of Columbia was really concerned with the high levels of gun-related crime in the city, so they passed the nation's most restrictive gun control law yet. The law essentially banned the private possession of handguns.
Shotguns and rifles could be owned, but only if the weapons were registered, kept unloaded, and were locked in a gun cabinet, disassembled or trigger-locked.
Dick Heller, a D.C. police officer, had been granted a license to carry a handgun while on duty as a security guard at the Federal Judicial Center. He applied for permission to own a handgun for self-defense, but he was refused.
Heller decided that the district's law violated his Second Amendment right to bear arms, so he brought a suit against the city.
Now for some background on the Second Amendment.
Go. The Second Amendment to the United States Constitution is the part of the United States Bill of Rights that protects the right to keep and bear arms. It was adopted on December 15, 1791, along with the rest of the Bill of Rights.
Go. George Tucker criticized the English Bill of Rights for limiting gun ownership to the very wealthy, leaving the general population effectively disarmed, and expressed the hope that Americans never cease to regard the right of keeping and bearing arms as the surest pledge of their liberty.
History shows that the militia during the Revolutionary War is an example of what the Founding Fathers wanted to protect by the Second Amendment. This is when everyday men took their own rifles to defend their beliefs and their new country.
The Second Amendment is obviously an auxiliary right that supports the natural rights of self-defense, resistance to oppression, and the civic duty to defend your nation.
This is what would happen if you lived in the District of Columbia, if the firearm law was still in place, and an intruder were to come into your home.
I didn't order anything.
Well, I got you some.
Oh, just a second. Just a second. I got this. Just a second. I got this. I got this.
I'm sorry.
This. Now how does it?
This is what would happen if you lived in the District of Columbia. The firearm law was not in place, and an intruder were to come into your home.
I didn't order anything.
I got it. Freeze! I said freeze! Bam!
Those are our two examples of what could happen with or without the law in place if you lived in the District of Columbia. Now we move on to the final decision of the District of Columbia versus Heller case.
You are about to enter the courtroom.
Order! Order in the court. I am Supreme Court Justice Antonin Gregory Scalia. I will deliver the majority opinion based on a 5-4 vote. The Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia and to use that firearm for traditionally lawful purposes, such as self-defense within the home. The handgun ban and the trigger lock requirement violate the Second Amendment. Similarly, the requirement that any lawful firearm in the home be disassembled or bound by a trigger lock makes it impossible for citizens to use arms for the core lawful purpose of self-defense and therefore is unconstitutional. Thank you.
Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon in any manner for whatever purpose. For example, concealed weapon prohibitions have been upheld under the amendment or state laws. The court's opinions should not be taken to cast doubt on long-standing orders that forbid the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws regulating the conditions and qualifications for the commercial sale of firearms. Please and thank you. Goodbye.